Arbitration Week. There she started again. Well, welcome everybody to Washington Arbitration Week 2024. My name is Ian Laird. I'm a partner here in Washington at Mauriello LLP. I'm here with my co-chair, Dr. Jose Antonio Rivas of Strategy LLP. This is the fourth annual Washington Arbitration Week. This was something that Jose Antonio and I and many people in the Washington community have talked about for years, about bringing together all of the great practitioners, arbitrators, and service people in our industry together and share our experiences and celebrate what a great place Washington is to do international arbitration. When COVID came along in 2020, this really was seen by us and our advisory and our great advisory group as an opportunity to do something kind of new and active, and something that actually really generated a whole ton of interest, which was a one-week virtual conference with 20 some odd sessions. And the take-up and the interest was fantastic. Well, a lot of people are sitting at home, so I think they think there's something to do, but also just the enthusiasm for arbitration here in Washington and supporting their practices and the community. So we're really pleased that we have this great group here today, and we have, I think, 20 some odd sessions and events coming up over the course of this week. It's really going to be a fantastic week. And here today, we're in JAMS, which, as you know, is a great supporter of Washington Arbitration Week, and we thank them for hosting this morning. There's some great institutions here in Washington, and JAMS is one of them. So thank you very much. It's really very much appreciated. We have a great panel this morning, and I'll call on my colleague, Dr. Rivas, to introduce and say a few comments. But the panel is called Judges versus Arbitrators, with a question mark. Judges versus Arbitrators. So however you take that, the next part of it is assessment of international arbitration awards by the Judiciary after Nigeria versus P&ID, which is a very recent case, as you know, in the London courts. So we're trying to be very topical, address issues that are very current in the international arbitration world, and I think we have a fantastic panel and very much looking forward to it. So I'm going to ask my colleague, Dr. Rivas, to come up to say a few words, and then we'll get going.
Thank you, Ian, and thank you everyone for being here, especially after Thanksgiving. So hopefully we're ready to for a full week of proceedings. We have about 20 to 23 panels this week, and my task is simply to say thank you. Thank you for trusting Washington Arbitration Week. And as Ian said, the Washington Arbitration community used to meet rather than in Washington, in New York, or in Miami, or in Italy, but we would never meet in DC. And thanks to COVID, there are things to thank for. We actually started this adventure. So this is the fourth year. We're really excited topics on international arbitration, commercial arbitration, investment arbitration, and also we're also getting into local courts, federal courts. So that's one of the features this year, trying to connect arbitration and courts. So we're very thankful to JAMS. Thank you for all your support, for the hosting, for welcoming me here. And now my immediate task is to thank Nicole Silva, who is now our moderator. And she has a long career in international arbitrator, in legal finance, and now as an underwriter of Ignite Specialty Risk. So Nicole, I want bother you with the whole list of accolades that you have. But thank you for being here and give it away. Thank you.
Good morning, everyone. My name is Nicole Silver, and I am head of U.S. Operations and lead underwriter at Ignite Specialty Risk, which is an MGA that partners closely with several insurance carriers. I'm also, as Jose Antonio said, a former litigator and international arbitration specialist, having worked in the field at Big Law for close to 20 years. And some of you may know me as the co-host of the Tea on International Arbitration. Today, we are here to discuss the intersections between arbitration and litigation. While there are obviously a handful of ways in which judges and arbitrators interact when it comes to international, we are going to discuss a very specific issue. That is when awards are challenged on the basis of fraud. The role of the judiciary in international arbitration is debated, with some advocating for greater judicial involvement in reviewing arbitral awards and others maintaining the importance of the finality of the award. In this panel, we use the recent Nigeria v. P&ID decision as a lens to examine the essential role that judges play in the cross-section of these two worlds. So that we can properly discuss this topic, I'd like to first introduce the panelists and then give you a little bit of background on the case. So first, to my right is Judge Robreno, who is a partner at Carter & English, where he serves as a mediator, arbitrator, and special master appointed by the court. Prior to his retirement from the bench, he served for 30 years as a U.S. District Judge for the Eastern District of Pennsylvania. While on the bench, he is best known for presiding over MDL 875, which is the asbestos products liability litigation. And he resolved there over 180,000 individual cases before closing the MDL, which I have to say is an astounding fact. Judge Robreno also serves as distinguished jurist in residence at the University of Miami Law School, where he teaches courses on MDLs, class actions, and other forms of complex litigation. Next up is John Laird. He is counsel with Cole & Mooring in London, and for the past decade, he has written on, studied, and represented clients in treaty and contract-based arbitrations involving states, as well as challenges and enforcement actions in courts. In addition, his practice involves a wide variety of commercial litigation in the English High Court, including the pursuit and defense of competition. To John's right is Matthew Kirtland, who is the winner of the best title. He's the co-partner in charge and head of litigation and disputes at the Washington, D.C. office of Northwest Fulbright. His practice is focused on international arbitration and transnational litigation. He has represented corporate and individual clients from a diverse range of business sectors. He's handled international arbitration proceedings for multiple arbitral institutions. You all know what they are. He also has handled ad hoc proceedings using the UNCITRAL rules, as well as other more specialized rules of procedure. In addition to his international arbitration practice, Matthew also has extensive experience in arbitration-related litigation, as well as cross-border litigation. And last, but certainly not least, is Michael Jaffe. He's a partner at Pillsbury here in DC. He focuses his practice on arbitration, litigation, and other forms of dispute resolution. He's frequently recognized among the most skilled advocates in international arbitration and U.S. litigation by, among others, Chambers USA, as lawyers, and Who's Who Legal. His specialty is construction disputes, and he serves on ICDR's distinguished panel of energy industry arbitration professionals. So, back to the judgment. The judgment in Nigeria v. P&ID Developments Limited, no, Nigeria v. Processing Industrial Developments Limited, P&ID, was published by the English Commercial Court just a few weeks ago in October. As many of you are aware, Justice Knowles found in favor of Nigeria, holding that the arbitral awards obtained by P&ID against Nigeria were procured through fraud and in a manner contrary to public policy. The underlying dispute between P&ID, a British Virgin Islands company, and Nigeria arose out of a gas supply and processing agreement concluded between the parties in 2010. Under the terms of the contract, Nigeria was to provide wet gas to gas processing facilities constructed by P&ID, which would process the gas into lean gas, which would in turn be delivered to Nigeria for power generation. The GSPA contained an arbitration clause with London as the seat of arbitration. In 2012, P&ID filed for arbitration, asserting failure by Nigeria to meet its obligations under the GSPA and claiming lost profits. In 2015, the tribunal chaired by Leonard Hoffman found that Nigeria had repudiated the contract by not supplying wet gas, and in 2017, it ordered Nigeria to pay $6.6 billion, reflecting the anticipated profits lost by P&ID over a 20-year period as discounted for present value. The value of the award has, of course, significantly increased since 2017. And by the time the High Court issued its judgment last month, the award with accrued interest was worth roughly $11 billion. Of relevance to the background to this case, it should be noted that the case before the English High Court was not Nigeria's first attempt to challenge the award. Nigeria had attempted to set aside the award on liability in 2016, but it failed due to, among other things, lack of evidence. However, Nigeria was able to relaunch its challenge to the awards in 2020 following subsequent and successful actions for discovery against P&ID in various courts internationally. And it is this relaunch, of course, that culminated in the recent decision that we're discussing today. Nigeria presented a broad range of allegations in the English High Court case, including that numerous civil servants, its internal legal team, at the relevant ministry, and even its own counsel in the arbitration proceedings were corrupted by P&ID. It also presented substantial evidence from disclosure documenting what were said to be payments and communications, evidencing corruption in relation to the entry into the GSPA. And P&ID's defense was broad and technical, but hinged primarily on the premise that regardless of the corruption alleged by Nigeria, the main reason Nigeria lost the arbitration was the failure of the relevant government ministries to properly participate in the arbitration and the incompetence of its counsel, which could not constitute grounds to set aside the awards. Ultimately, the High Court agreed with Nigeria, finding that P&ID, one, had paid bribes to a woman called Grace Taiga, a former legal director at the Ministry of Petroleum Resources and one of the lawyers involved in drafting and negotiation of the GSPA on behalf of Nigeria. Two, that P&ID had knowingly tendered witness evidence in arbitration which concealed the fact that it had secured the GSPA contract through bribes paid to Ms. Taiga. Three, continued to make payments to this Ms. Taiga during the arbitration proceedings to buy her ongoing silence. And four, improperly retained and misused Nigeria's privileged and confidential legal documents to assess whether its corruption had been uncovered by Nigeria. At this point, the High Court has yet to decide whether to remit the award to the tribunal in whole or in part for reconsideration, set aside the award in whole or in part, or declare the award to be of no effect in whole or in part. So against this rather wordy backdrop, I'm sorry about that, but I wanted you to understand the case. We are going to turn to the court's judgment, which highlighted in very plain terms some difficult issues around the role of arbitration in international deals where corruption has been alleged. So in the decision, Justice Knowles expressed concern about the suitability of arbitration as a dispute resolution process in situations like these, noting specifically that the arbitration was a shell that got nowhere near the truth. He questioned whether the arbitral process was robust enough to fairly evaluate all the issues, suggesting that even with an experienced tribunal, such as the one in the case, arbitration was, quote, less reliable, less able to find difficult but important new legal ground, and more vulnerable to fraud, end quote. So in raising these concerns, Justice Knowles highlighted that the disclosure orders made by the courts, and not the arbitral tribunal, were key to discovering the true depth and consistency of corruption in the case.
And as a second but not last criticism of the arbitration, Justice Knowles also stated that although challenges to arbitration awards are possible, they are by no means easy or even likely, and that Nigeria had to utilize significant resources to succeed on the challenge. Thus, while acknowledging that the arbitration process is important to dispute resolution, he suggested that it may need revising for high-value cases where the state is a party to the proceedings. So I'm going to stop talking now and hand it over to our panelists to discuss some of the concerns about the arbitration that Justice Knowles has highlighted. And I suggest that we start with you.
Thank you very much, Nicole.
I see it is, but I can't.
Okay, we'll do it this way. Let me begin first by saying thank you very much to James. Meeting this morning. I'm accompanied here this morning by a colleague, Postgre Gary Shaw, who has helped me a lot in pulling together some materials for proceedings today. What I'd like to start with is what was the responsibility of the counsel in this case? Clearly, P&ID's counsel saw lots of red flags. They knew that they were getting information that was confidential information protected by lawyer-client privilege and didn't do anything about that. Didn't report it to Nigerian counsel, didn't report it to the tribunal. They kept it secret. They were aware of Justice Knowles' decision that there was a good deal of impropriety and did nothing about it. And at the end of the day, Justice Knowles referred to the appropriate group's review of counsel's behavior, professional response. So the question is, where you have corrupt counsel, I don't care whether it's an arbitration proceeding, an investor state proceeding, a commercial proceeding, a court proceeding, there is something just fundamentally wrong. Counsel for Nigeria, I think it's fair to say, as Justice Knowles did, that they were pretty much asleep at the switch. There was a lot going on that they just didn't pay any mind to. To me, that's really where the issue starts, because as counsel indicates, when you're seeing red flags, such as why was this contract made at all? Why was there a default at a time when P&ID had not acquired the land to develop the engineering for the project? It does nothing to move the project. Isn't it a bit curious that you have all combined at that point when you look at the financing for the defense, to hire any sort of responsible consultants on the damages side, failure to raise even fundamental issues such as all of the damages would be speculative. They talked about Henley versus Baxendale, but from a totally different vantage point. So there were lots of things that were going on. And sitting on the tribunal, you might have wondered, why was this happening? What was going on? I think in the first instance, the responsibility of Nigerian counsel to recognize that they were in over their head, that there was a lot going on, yes, and not to step forward and say something is really fundamental. What's further interesting, at least to me, is here in the United States, Justice Knowles' decision would go the other way if the corruption and bribery were all that were stayed, because under the New York Convention and non-USC Section 2 at SEC. What you have is a situation where if the proceedings themselves are not corrupt, then in fact there's bribery, securing of the contract, misconduct outside of the arbitration. Case law in the United States is that's not reviewable under Section 10 of the statute. It doesn't fall under the exceptions in the New York Convention to invalidate or here, however, I think the decision would have been the same in the United States, principally because improprieties reached all the way into the arbitration proceedings in a number of ways that justice was recognized. There is a temptation to take an aberration, and I think this case is an aberration. Apparently, my mother's home. It's an aberration, and it's something that there's a temptation to write more rules to have appealed to Congress to broaden 1782, which the Supreme Court is very much narrowed in the decision that raises many questions as it answers. But I think that we should resist that temptation. I think that fundamentally international arbitration states disputes where you have competent tribunals, you have competent counsel who can deal with these kinds of situations. There are places in the world, at least according to Justice Knowles' decision, Nigeria being one of them, where corruption is part of doing business, and when you're involved in counsel or as a matter of member of a tribunal in disputes that arise from this process. I think it's important that your entire be especially to are there problems here beneath the surface that I should be aware of. And as counsel, when you see that, I think you need to speak up. And in this case, Nigerian counsel had access to the president of Nigeria, but it was too little.
Thank you, Michael. I don't know if that microphone is working, but we're going to turn
Give it a shot. Jesse, it is working. Well, thank you for the invitation to join the distinguished panel and distinguished participants on this important topic. And as Mr. Jaffe has sort of framed the question, the issue ultimately is there a need for some modification or amendment to the international arbitration process as a result of the Republic of Nigeria case? My role here today is to flesh out the how the case would have fared under the American judicial system, whether there's something peculiar about the system or whether it was simply a case of extraordinary corruption and ineptitude, a sort of a perfect storm that brought about this case. And I do want to join in and emphasize what Mr. Jaffe has said. That is, whether an unusual or extraordinary case then motivates or warrants amendments that would apply to the more ordinary cases, which appear to be working well. So what I wanted to do is perhaps review a little bit of how we got in the United States under the American system, to a balance, to an equilibrium between the role of the judges and the role of arbitrators, and to see whether or not we have, through that process, come to a point where that balance works in practice. Justice Holmes said many years ago that a page of history was worth a ton of logic. And I think that in order to understand and to try to evaluate the merits of that relationship in the United States, it is worthwhile to take a moment and look back to how we got to where we are today. Of course, arbitration was for many years disfavored by common law courts who viewed arbitration and any effort to try to resolve private disputes outside of the contours of the court as an invasion into the scope and the responsibility of the court, even the responsibility under the Constitution in Article 3, which vests the judicial power on the federal courts. That was prevalent throughout the 19th century, perhaps the early part of the 20th century. We ultimately had the benefit of the Federal Arbitration Act in 1925, and an interesting development occurred during World War II. That is, as a result of the imposition of wage and price controls, a World Labor Board was put into place. What happened after the war with the creation of the World Labor Board is that a number of very distinguished arbitrators who were trained in the World Labor Board served as the arbitration demands of the country. People like John Dunlop, Archibald Cox, and others that you may have heard about it, professionalized the arbitration process and gave it the kind of legitimacy with which the arbitration process is flowed in today. Ultimately, the Supreme Court, beginning in perhaps in the trilogy cases in the 1960s and following in a variety of cases for the last 25 or 30 years, has accepted and promoted the idea of arbitration as a legitimate way of resolving private disputes. Now, how do we then balance the responsibility of the court, which uses public power under the Constitution, with the responsibility of the arbitrators who are vested with the private power that the parties have vested in with as a result of the arbitration agreement? Now, I'm going to break it down into three areas where that relationship takes place, and I think we can then try to apply that to the Republic of Nigeria case and see how it would have fared at that particular point. First, should the arbitration take place? We have a private agreement, but nevertheless, the parties are free to go to the judicial side and either stay the arbitration or compel the arbitration. So we have an interaction at the very beginning of the arbitral process between both the judges and the arbitrators. As the arbitration goes forward and it is presided over, the designated person who the private parties have asked to arbitrate their dispute, the parties may seek the assistance of the court in compelling the attendance of witness or production of documents. He may do so and may sanction failure to do that. So there is some assistance from the judicial process to the arbitral process throughout it all. And ultimately, once the award is reached, is entered into by the arbitrator, that award may be enforced in the courts. Either may be enforced, may be vacated. That is, the court will have the ability and the authority to ensure that that arbitration is consistent with public policy. So how do the two work together? And I think that ultimately our our experience has been that arbitration is a private agreement where the parties have vested upon the arbitrator the power and the ability to resolve their dispute. And that dispute is not reviewable by the court on the basis of merit. That is part of the agreement that the parties have entered into is the possibility that the arbitrator may enter the wrong decision. And it is not vested upon the court the ability to review the merits of that particular decision. So, provided that the decision of the arbitrator falls within the scope of that authority, and provided that it does not violate public policy being as outlined in the Federal Arbitration Act, fraud being one of the exceptions under the Act, that award should be and will be enforced. So, what does that do? And that particular protocol that I have just described, how would it have worked in the case of the Republic of Nigeria? And I think that each of the three steps that I have outlined, that there would have been an interaction between both the arbitrators and the courts. At step number one, the evidence or the claims that there had been fraud in the procurement of the contract between the parties would have been presented to the arbitrator. Step number two, to the extent that one of the parties was not complying with discovery or was perhaps doing so in an improper manner, that manner could have been brought to the attention of the court. And ultimately, to the extent that the arbitration award had been procured by fraud, clearly in the Federal Arbitration Act, that also would have been brought to the attention of the court and could have been remedied there. So, I think my parting words in terms of evaluating the impact that the Republic of Nigeria case is going to have is that the case is, as Justice Knowles indicated, brought about the confluence of corruption and ineptitude. That it is an unusual case, it's an extraordinary case, is not a case that should present the basis for reforming or radically amending the arbitral process. That at best, I think it makes a suggestion that we could have some particular attention to cases where there is a good deal of money, where a sovereign is involved, where it's a high-profile case. But in the ordinary case, I think that ultimately the case will not have an impact beyond these own facts.
Thank you. Matthew, I'm gonna turn it over to you.
It's working. Thank you, Nicole. This is working. Thank you, Nicole. And now it's a pleasure to be here to speak on this distinguished panel. And I also thank the organizers and Mauriello for assisting in setting up this panel. It's a fascinating case, the Nigeria case, and it illustrates what I think is a bit of a hole in the system in which we all participate. And the hole is procedural fraud. Fraud, by definition, goes undisclosed. And here in the Nigeria case, and other cases where fraud is involved in arbitral awards, the fraud by the party, by the investor, by definition, is not disclosed to the state in advance of the arbitration. And here in the Nigeria case, where there was also procedural fraud, that by definition goes undisclosed by the attorneys, the gatekeepers that Michael referred to. And when an award that is tainted by fraud is brought before the courts of various countries, either for confirmation or for set aside, there are oftentimes, we've found in other cases, there is a premise by the courts that the party, in this case the state Nigeria, had the opportunity to investigate and to litigate this alleged fraud as the grounds for the set aside or refusal of confirmation. And oftentimes it simply is not true. There's a line from Justice Knoll's decision that bears repeating. His quote is, "It has been disclosure or discovery of documents that has enabled the truth to be reached in this case." Now, all of us here in this room and attending on Zoom who practice before international arbitration know that disclosure of documents in international arbitration oftentimes is far more limited than in domestic court proceedings. And significantly, for fraud issues, there is, in most international arbitration sets of rules, almost no third-party discovery. Now, attorneys who represent clients accused of fraud and attorneys who prosecute fraud know that third-party disclosure and third-party discovery is oftentimes critical to uncovering fraud. But in international arbitration, oftentimes that third-party disclosure or discovery simply does not exist under the agreed sets of rules. And that's why fraud can go uncovered. What's ironic in this case is that evidence that was critical to proving that this award was obtained by a fraud were obtained by 1782. As a result of the U.S. Supreme Court's decision this year, 1782 no longer is available to support international arbitration. And you can agree or disagree with the wisdom of that decision, but it is the accepted fact now. Whereas in the confirmation and set-aside proceedings, it is available. So you have this imbalance in evidence. There's also a very critical point here on this case, which is the selection of the seat. Clients often come to us, international arbitration practitioners or transactional attorneys, with a dispute resolution clause that's already drafted with little room for revision, or it's set in a treaty. And there are various cities considered safe seats, as we all know. But what's, I think, sometimes flies under the radar is the substantial differences in procedural rules for confirmation and set aside between the various seats. This arbitration, the Nigeria arbitration, was seated in London. And London has London is an outlier in the procedural rules that apply to both confirmation and set-aside proceedings. Consider this. This award was issued in 2017. And as Nicole said, Nigeria had tried to set it originally, the liability component, at the correct time, which is 28 days is the rule under the English Arbitration Act. And it was refused. They then discovered evidence of the fraud years later, and they brought their application in 2020, 3 years after the final award was issued, to set aside. The English High Court, not Justice Knowles, but another judge, held a 2-day evidentiary hearing as to whether they would be permitted to put on their fraud case. 2-day evidentiary hearing. The chances that you would get a similar hearing in the United States are zero. That you would get this in another jurisdiction are very low. This was just on the question of whether they could present the fraud case. Then, when that was permitted, full disclosure was ordered, supervised by the court in the set-aside proceedings. That led then to an 8-week trial before Justice Knowles. And this is radical compared to other countries that are considered to have safe seats. An 8-week trial on a set-aside proceeding preceded by full disclosure. By way of comparison, we're involved with a case that's been ongoing since 2013 for 10 years, where we represent the Republic of Kazakhstan against a set of Moldovan investors known as the Stadis. In 2017, we had a proceeding before Justice Knowles. We put forward our evidence of fraud. We also had a 2-day hearing. He allowed it to proceed. That same exact case was presented in Sweden and not accepted in Sweden. Now, in our case, the difference was that Sweden was the seat versus London. And after we established the necessary prima facie evidence of fraud, the investors, represented by a very prominent law firm in our space, withdrew their proceedings rather than go to full trial. Now, that was permitted because this was a confirmation proceeding in London in our case, whereas here in the Nigeria case, it was a set-aside case. So Nigeria had it within its control to proceed to trial, no matter what, when it's full fraud evidence. But here in the US, with the same case that was accepted as being fraud in London, in our Kazakhstan case, the US District Court here in DC didn't even give us a hearing, much less allow the case to be presented. And so you have this sort of an imbalance between what are considered safe seats and the procedures that are available. You also have a difference in applicable law. England, as we all know, has one of the strongest anti-fraud laws that exists amongst what are considered safe seats. And you also have, I think, in the English judiciary, unlike in some other judiciaries, a duty of inquiry that sometimes doesn't exist. And Justice Knowles gets to this in his decision when he comes to his 4 sort of end note points, where he asks, what should the tribunal have done? Should it have asked questions? Now here, a fraud was concealed from the tribunal, but still, as he notes in another part of the decision, corruption is endemic in Nigeria, as well as certain other developing states. Should the tribunal in that case have inquired whether fraud existed affirmatively? It wasn't presented by either Nigeria or by the investor, of course, but the tribunals didn't ask the question, even though it's certainly not outside the realm of possibility that the investor here had been engaging in fraud. I would say, and my submission is, that an arbitral tribunal, particularly in a public case such as this, as opposed to private commercial arbitration, does have a duty to inquire. And Justice Knowles brings up very serious allegations about this very distinguished panel not inquiring when it was apparent that Nigeria's counsel was not asking the correct questions. And of course, here, Nigeria's counsel, the allegation is that they too were corrupted. And while Justice Knowles rejects that as a conclusion of law, he does raise very serious questions about their competence. And this goes to Michael's point about Nigeria's counsel was sort of asleep at the switch. In that instance, with such a large case involving treaty claim as opposed to private arbitration, I think there is a duty to inquire. And I would also say in the judiciary, that when competent evidence of fraud in the proceedings is presented at a prima facie level, that the judiciary, both in the US and in other New York Convention states, also has a duty to inquire. Because I think, as Justice Knowles rightly points out, the concept that international arbitral awards, particularly against states, have been tainted by fraud is an existential threat to the ISDS system. And it should be rooted out. And the judiciary has a very important role to play.
Great. Well, you have previewed for me a bunch of questions, and I really do want to get more in depth in a sort of roundtable discussion about a lot of the issues you have just flagged and set up for us, Matthew. But before we do, we are going to hear from John about one of the other topics that Justice Knowles raised, which has to do with the amount of damages that's taken in this case and what happens when we're litigating against a state.
Thank you very much for everyone here today. Thank you, Ian, who is running the show here with us, Antonio, but is in fact no relation to me, even though we work together and do exactly the same things. Thanks very much to you and the panel for your interesting comments so far. And certainly the direction that we were going at the very end, Matthew, I think is one of the leading almost directly into the kinds of things that I was going to discuss as well, but also there's a slight interesting tension in the nature of looking at giving, as you say, the chance of someone to make their case on fraud at the same time as assertions about whether or not people should be making inquiries in the first place earlier. And indeed, one of the things that was being P&ID were trying to do was to say it's all too late. You left it for investigations and you knew enough, and you should have done this a long time ago. And Mr. Justice Knowles gave Nigeria the benefit of the doubt, most particularly on things like it may be endemic to Nigeria at certain times if there was fraud going on, bribery going on, but was there evidence that was going on specifically in this case to the notice? But this all leads to why are we actually even talking about this? And the real reason is sitting at the top of the judgment, Mr. Justice Knowles, that he calls it a sum so vast that it is material to Nigeria's entire federal budget. And I think that's the real interesting question for the development of law here. And that is, why is it that we care that it's $11 billion against the state? Why is it that we might think that $11 billion for a process contract like this is a lot of money? Is it too much money? And a lot of that goes back to questions which have been pushed in the international law on state responsibility for a long time now, but have never really gone anywhere in quantum. They've gone places in liability to do with questions like proportionality and whether or not states should be given a break, basically, when something is big and important and then it goes wrong, and it would have gone on for 20 or 50 years. And a traditional calculation of lost profits is, well, this was going to be making several $1 million a year for 50 years, and that turns into scary big sums if you just say, give them the money for what they would have made, but for the breach. And I think that leads to two particular questions there is, what went wrong in this arbitration could even be potentially attacked by the, Mr. Justice Knowles is pretty close to saying that despite the experience of the panel, did they just simply get it wrong in and of themselves? And we'd be here talking about any of this, would Nigeria have been looking for fraud if instead there's been nominal damages? Because ultimately, this is a case where there was no gas given, and there was a found repudiation of the contract. And traditionally, we understand under English and in Nigerian law as well, that will mean give over in damages the whole of the bargain. But do we really do that? Does that make sense, whether it's state or otherwise, when the situation is, yeah, but they didn't do anything. They hadn't spent any money. And there's a lot of cases in investment arbitration law where tribunals at that kind of stage, even if it could be established that there was willingness and an ability to move forward, but the state had cut off a project before it had ever really gotten anywhere, then all you really should be entitled to is essentially your sunk costs. And English law as well has, puts in the hands of the claimant, most of the time in damages, whether or not they want to seek their expectation or their reliance losses. And so really one of the interesting questions as well for me about this whole case is, are there, and as Mr. Justice Knowles suggests what to be developed in laws, whether there's room here for looking at scenarios like this and saying that we need to develop the law of damages itself anyway.
Thank you. So I'm just gonna throw out some questions, and the first one Matthew teed up quite nicely for us, and that is, so how does the decision here contribute to the transparency debate and what it might mean for the future of ISDS, which seems always to be under fierce criticism for both the lack of transparency and even the reliability of the arbitral process? And I don't know if I want to, would you like me to turn this question back to you, Matthew, to start with, and then see if anybody else wants to chime in?
Certainly, Nicole. I think because of the publicity given to the decision, it sets a flag in the sand for the debate about transparency, and it's in that way very beneficial for the community. it's not as if the Nigeria case is the first award where fraud has been in play. I'm sure folks in this room all remember the Churchill mining case, which Vandenberg chaired, and it was the award was not reached in that case. It didn't even get to final award because the operative contract in Indonesia was secured by bribery. But here, I think the decision does contribute in a positive way towards the debate on transparency. In particular, I think what's gotten the attention of our community is the excessive compensation arrangements to the attorneys for P&ID. I mean, even in the realm of I paid English barristers, a $3 billion success fee creates, as Justice Knowles said, some perverse incentives. And he also then referred the counsel during the arbitration to the SRA and to the bar for potential disciplinary proceedings. And so I do agree with Michael's comments that the lawyers are the gatekeepers in any legal process, but particularly in international arbitration where there's more limited disclosure and adverse proceedings. And so I think it's good, and I think there does need to be more transparency and more affirmative duties.
I think what Matthew has highlighted is there's really a difference between investor-state disputes and ordinary commercial disputes, if I can use that. Because in ordinary commercial disputes, one of the things, forget when that works, in ordinary commercial disputes, it is a lack of transparency that is attractive oftentimes to the parties. The fact that they can conduct the proceedings without them becoming public, without the dispute being something that is going to pour out into the press, at least until we get to the point of either confirmation or an application to vacate the award when the proceedings do have to, at least to some extent, become public. As well, there is an interest in limited, using our word, discovery, whether it's in terms of the scope of document production, the absence of other means of obtaining information, and the lack here in the United States of ability to get information from third parties, at least other than before a tribunal. So I think we should look at the question of transparency in the context of the nature of the proceeding. If it's a typical commercial dispute, I think that too much transparency would deter people from wanting to use arbitration as opposed to going to a public court proceeding. When it's an investor-state issue and where the state has such a major amount at stake, as in this case, although it ranged from as low as 850 million up to 11 billion, where you have a state interest, even if the money is much, much less than what we're talking here. I think that confidence in the process is really important, and therefore more transparency. And I'm troubled by the Supreme Court's decision involving 1782, which really doesn't tell you when is there a government decision to invoke the arbitration process. It's not a proceeding where the parties have agreed. It's something more than that. And so it seems to me that that is the place that we should be looking to improve the opportunity for people to get third-party discovery.
We're definitely going to touch on that in the next question. But does anybody, before we get to that, want to respond to transparency before?
Well, it is often said that hard cases make bad law, but this is an easy case that makes bad laws. The corruption here, according to Justice Knowles, was pretty apparent from the start. There wasn't much that was hidden from you, and it was a matter of I guess insiders taking advantage of the system. But I do want to maybe caution that any efforts to increase the review of arbitral awards, of course, undermines the very principle of the arbitration, which is a private agreement between the parties. That private agreement may carry with it the possibility that fraud may occur. And although there is a proper role, I just would caution that overreacting to it may disturb that balance and place perhaps shift some of the authority and some of the attractiveness of the arbitral process to the judicial side of the equation.
All right. So, we've talked about, and many of you have raised the fact that the crucial information relating to the bribery and corruption in this case was obtained much after the arbitration proceedings had closed. And it was obtained via the English court and other international courts. And that without this discovery, the truth of the fraud may not have been discovered, even if it was, as you just pointed out, Judge Labrena, rather obvious, or should have been rather obvious to the tribunal. Potentially one of the problems and why this arises is because, as Matthew said, and as all of you know, discovery is pretty minimal in arbitration proceedings, and would, as just putting it out there, would justice be better served if, one, the powers of arbitrators were increased, potentially to sanction parties that don't comply with orders to produce, or should we encourage closer cooperation with national courts to obtain appropriate orders? What should we do? And I also want to circle back to Matthew's point about 1782 actions. And I would note, having been involved in a lot of cases, which 1782 was used, there was no question that discovery obtained from Section 1782 actions shed a lot of light in the Chevron and Ecuador case. And I think it's fair to say that those discovery actions, which included document production and depositions, actually changed the course of the arbitration. And that was because it was through these 1782 actions that Chevron was able to demonstrate fraud. And I think that there were probably close to 50 1782 motions in that case. And now, as Michael said, or as Matthew said, someone said, the avenue has seemingly been closed as an option to the parties by the Supreme Court. And so my question to you all is, what's next? Should there be a more robust discovery practice in arbitration? Should arbitrators have greater powers? Something entirely different? Should, as Matthew indicated, should there be affirmative duties on the part of the tribunal to get into fraud and issues of corruption, even if they are not raised? So, or are things fine as they are? So, to you and whoever wants to start first.
Can I add something to the end of that question?
Yes.
And if so, in what circumstances?
And if so, in what circumstances? Thank you.
Well, quite. I was going to say that there's again a tension, which I think is going to what Mr. Jeffrey is saying about the distinction between involving states and private parties, and that also goes to what you've been saying about the privacy and the agreement of the parties and what an arbitration is. The more you end up creating extra powers for arbitrators to do things which involve third parties, the more it starts looking like a court proceeding, I think, to me. And then you start getting more and more towards, at what point is this actually purposeless, because the entire point in the first place was to allow people to say, I don't want to use the particular rules and procedures of the court of whatever jurisdiction, I want to do this my way. Equally, the real problem, as Matthew has been saying, is that when you've got things which are deceiving the tribunal themselves, then you may need to actually go elsewhere and the two parties to get to the root of the problem. So for me, the question is purely in a realm of perhaps some form of reform, specifically on questions like this, with some kind of idea of probable cause to go outside a normal arbitral process, but otherwise things would remain much as they are. The 1782 issue, I think, is one of those things which has been useful for many people for a long time, and it basically cries out for reform, and there has been an Arbitration Act reform effort in England recently, so you never know if someone in the US might care to fix that one. The Supreme Court has done something about it.
It's a very provocative question. I think I agree and endorse the distinction between private arbitration and public arbitration. There is a fundamental difference between a treaty-based arbitration, which is not a private agreement between two parties, and therefore none of the concerns of confidentiality and privacy of proceedings and more limited proceedings, and arbitration, international arbitration, as a faster, more effective route for sensible business persons to conclude their disputes need be impacted. But when dealing with public arbitration, which necessarily treaty-based claims raises public interests, I think that is where reforms could be made. And I think one thought is whether a tribunal has a duty to know its parties, sort of like the KYC rules and regulations that have swept through the entire banking, auditing, and legal industry over the past 5 to 10 years. And whether tribunals should consider having a set of uniform know your party guidelines. Because in this case, the Nigeria case, what's striking is that it was very much an inside job. You had the attorneys for Nigeria were, by implication, in on it. They were feeding documents. The Nigerian government, under bribery, was feeding internal confidential documents in the arbitration to the Investors' Council, and the Investors' Council did nothing. But the tribunal had it asked, and this is by no means to slight the individual tribunal members, but a tribunal, by simply asking a set of fairly standard questions, could likely have rooted it out, this fraud, or set up very clearly a defense to confirmation and or grounds for set aside, as opposed to having an incomplete trial, because then the parties would have been lying to the tribunal overtly. That's one sort of creative proposal.
I just wanted to have one follow up on what you were saying there. That suggests to me aspects on the whole question of active tribunals and paying attention to things that suggests that reform is perhaps necessary for these kinds of activities, to tribunals to get in the face of parties more than they do. And that example for me comes out of, again, the recent reform proposals for the English Arbitration Act, that despite the general exhortation in section 33 that tribunals should adopt procedures which they think are appropriate to the case, and this is basically begging the tribunal directly in overt statement, up to you, get in there. They don't get in there very often in one particular way, which is that they very rarely actually try to make decisions to curtail obviously bad claims or obviously terrible defenses. And so one of the reform proposals, which has now been accepted and was put before Parliament after the King's speech, was that a new section would be inserted towards the idea of an express procedure for summary determination of cases. So you can see from things like that, when it was totally within tribunal's power to decide, we should get this over and done with quickly. This obviously looks silly to me, but they aren't doing it anyway, and they're now having to be directly encouraged with statutory reform. Similarly, it may be required for these kinds of things to overtly encourage tribunals with more statutory language like that of pay attention to these kinds of issues.
One of the things that I'm a little concerned about is the difference in the way these kinds of issues will be seen in different parts of the world, including a directive from a tribunal to produce documents. Some years ago, I was teaching at Western American University Law School, and an ethics issue came up in terms of appropriately responding to a request for documents in the tribunal saying that the party should respond. And a number of students from South American countries were rather shocked that someone would actually produce a document that would be disadvantageous to its client's position. They just wouldn't do it. And it would be seen as completely inappropriate for them to do it. And so I think as we sit here and we talk about rules and tribunals and things along those lines, we should be mindful of the fact that not everyone sees these issues the way we do.
All right, I am mindful of the time, and I have some other questions, but I also would want to give the audience some time to ask questions if there are any. Anyone? All right, let me ask another question then. So you sort of flagged this, sir. So to the extent we haven't touched on it already, I wanted to talk about corruption defenses specifically, and how can dispute resolution best deal with the state trying to avoid contractual responsibility arising from its own officials' prior corruption. And, is this case sort of a freak example, which is driven by the apparent continuation of corruption by the state's dispute resolution council, or does it have interesting lessons? And, if the latter, what are they?
The complaint by the Republic of Nigeria that there was corruption in the arbitration reminds me of the line in Casablanca. Gambling is going on here. They were shocked. Where are your winnings? In a sense, it's shifting a bit of responsibility from the party to the process itself. After all, they're complaining about corruption within their own side of the equation. But I think a couple of things become clear here. One is the difference between private and public, and whatever reforms need to be instituted, probably limited to the public sector arbitration. The second point is the question of the duty to inquire, and which I think, again, under certain circumstances may be appropriate. The idea, though, of the adversarial system is, of course, that the adjudicator depends upon the parties to bring matters to the attention of the tribunal. The duty to inquire, unless carefully tailored, would, in a sense, run counter or create some tension with that particular proposition. Now, the question in this case, of course, is that the adversarial system was missing, had failed, and when the adversarial system fails, does the court, does the adjudicator have a duty in the public interest to insert itself into that particular controversy? So although I think the duty to inquire under certain circumstances is appropriate, it needs to be, carefully tailored, so as not to have the tribunal put the thumb on the scale of the merits of that particular case.
All right, well, with that, oh, do you have a question? Otherwise, I was gonna end it on Casablanca.
Just a question on the facts. I mean, you know the case way more than at least me. Do you think that the tribunal itself it should have been obviously the tribunal that what was going on, and therefore they should have been more active so as to sort of move away from the adversarial system and come closer to what would be known in civil law systems as more of a inquisitorial system. Would you suggest that in public international law arbitrations that active role is assumed by the arbitrators or the tribunals because it's more public? And this is a question for everyone.
I would say so. I mean, it's obviously something that can go too far, but what Justice Knowles points out is that it was fairly obvious that counsel for the state in this case was not performing their basic function within the adversarial system. And in this instance, where the other side is not the individuals representing the government of Nigeria, it's not the president that is the counterparty, it is the Nigerian people, that a public law tribunal, while not perhaps going to the full inquisitorial model of some civil law countries, perhaps there's a happy medium where they could do something rather than just sit back and watch it unfold, particularly in instances where you're dealing with emerging markets, where there is known to be corruption. This is not, as going to the Casablanca quote, the concept that there may have been bribery or corruption involving a natural resources contract in Nigeria. It's not shocking to anyone. And so when you're sitting as a tribunal, perhaps that could be taken into account to go into this sort of medium inquisitorial position.
I think in that regard, the devil is in the details. How far does the tribunal go in asking questions, in asking for information to be provided? Is it appropriate for the tribunal to ask, why aren't these defenses being put forward? As an advocate, I would not be all that happy if the tribunal is basically giving my opposition points to make that perhaps they hadn't thought of. On the other hand, there may be very legitimate tactical reasons why an issue is not being put forward in the case. And so I think the problem, as I said at the beginning, the devil is in the details. What is it that we're going to ask tribunals to do? When are they crossing the line? And I recognize there is an important need for transparency, especially in public international arbitration.
The concluding remark is, first of all, do no harm as a rule of process.
Well, my concluding remark goes back to where I started at the beginning. I think that there is more than anything else an inquisitorial role in any system for looking at relief and damages in a way that there isn't for forms of liability, that they are inherently open to more discrimination and discretion in tribunals. And I think this is an example case where, dare I say, I think that despite the failure of efforts on the respondent side, that the majority of the tribunal was too open to not sense check, essentially, a outcome which we would therefore not be talking about today if it had turned into the dissents, $250 million.
All right, well, I am going to thank you all for being here today. Thank you to our panelists. Thank you to Washington Arbitration Week. I'm going to, as having the honor of being the first panel, I'm going to not take you off track, and I'm going to let the next panel get ready and prepare. I think it's on diversity and inclusion. So welcome to Washington Arbitration Week, everybody, 2023.